Well, hello again. My name is Jeffrey Davis, and this is Radio Entrepreneurs. And we are for the record, which means we're up at the law firm of Tarlow, Hart, and Rodgers. Thank you to Mark Furman for hosting us. That also means that flanked to my left is the one, the only, Mark Z. From Mark Z Legal Staffing. Hi, Mark.
Jeff, great to be with you, and very excited about our guests, particularly our big guest coming up.
Well, why'd you make the gesture so big? He's not that big. Well, I'm going to let you do a lot of this interview. I'm a little bit under the weather today, but I had to come in. You begged me last night in 27 emails and texts. Little exaggeration. Don't worry, Michael.
Correct.
You're not that popular, Michael. And, remind everybody, even though this is a legal show, attorneys can be entrepreneurs. And that's a little bit of what Michael Chinitz, our next guest, owner of Chinitz Law Group, is himself, because you've straddled both worlds, haven't you?
I have.
Right.
So I began my legal career a long time ago, back in 1988 at Nutter, McLennan and Fish, which is still a prominent firm in the city. And I was there for 8 years, and then I left to do something entrepreneurial at that time, which was to join a former senior litigator and trial lawyer from that firm, Alan Rose. And I was the third person into that firm, which later grew to be a very prominent Boston boutique, maxing out at about 9 lawyers and 5 or 6 support personnel. I thought that was an entrepreneurial venture, but it was nothing compared to what I did next, which was I decided just a short while ago, at the beginning of June, to open up my own firm in Needham, Massachusetts, about 2.7 miles from my house in West Newton. And, there's a lot of advantages to being an entrepreneurial lawyer, which is that you call all the shots. Everything is yours to succeed, yours to fail, and 100% independence. And I've found that in the short time I've been there that you can perform at a very high level, that your referral sources that thought of you as a Boston lawyer will stay there.
Mike, so what I think is very interesting is you straddle not only the entrepreneurial world, but you also are an amazing litigator, but you're an advisor. So a lot of our audience are businesses of all sizes and shapes. And to have somebody who, when things get rough and tumble, they can go in and can make things happen in terms of settlements, but also can continue to advise them how to avoid legal pitfalls to successfully operate their business. Tell us how you straddled your both worlds.
Sure. Well, the truth is no one wants to litigate. Litigation is expensive, it's distracting, and often the outcomes are very, very unsatisfying. So the goal is to accomplish business objectives in an efficient way, and that could encompass things like alternative dispute resolution or just crafty negotiation, and also stopping the problem at its inception. And so, although I'm not a corporate lawyer and I don't form companies and I don't take companies through major corporate changes, I advise executives and I advise companies, both startups and emerging companies, in a lot of ways.
And one of the things you do in advising, because one of the areas you're strongest in, is the employment world, besides the specialty litigation.
Oh, that's a favorite of mine.
Yes, and Mike is very prominent and one of the leaders in that area, and a lot of our business owners are constantly dealing with issues. Now, what's interesting is in the recent debates, we heard the politicians talk to Michael Bloomberg, who a very successful business person, about harassment settlements and employment settlements, and they asked him, well, you can open these up and give people permission. Can you talk more about it? Because a lot of business owners get scared about that.
I want to add to Mark's thing, and I'll come as a management consultant. In this PC world, and I'm not making a judgment, should be, shouldn't be PC, most entrepreneurs I meet, they're scared. They're scared to be alone with employees. They're scared of accusations. They're scared of real ones, not real ones, how things are being interpreted. It's a diverse society. And when you do sign these deals, for whatever reason, they're signed for a reason. They're supposed to be confidential. And then they're asking to open up confidential deals.
Yeah, the whole objective of entering into an agreement is to avoid a protracted litigation matter. And the value in those deals is the confidentiality. The value is also the non-disparagement, which means that your company won't just be defamed, but it won't be criticized and it won't be mentioned in the press or otherwise by the purported victim or the claimant, and for that matter, other people. And so the notion of you entering into a deal where the value of that deal is obviously buying peace, but also buying freedom, from adverse publicity, to just open that deal up. First of all, you're not at liberty to do it because if you do it as the company, then all bets are off with respect to the claimant.
Right.
And so the sanctity of that
and
has
both
to
sides
be
don't sign the deal unless they're both in agreement that this is the way it has to be.
correct. And it's very, very rare for a deal, even at the higher levels, of corporate America. Obviously, if we're dealing with a publicly traded company with something that's very, very celebrated, there's going to be some press release. But in companies, local companies, regional companies, the goal is for the matter to go away.
Right.
And a lot of what you'd be paying for is silence, with some exceptions. There are some exceptions that we cannot avoid as business people and as company owners. If the EEOC or the MCAD wants to take a look at it, obviously you can't shackle that person.
Right.
There are exceptions to confidentiality. There is exceptions to non-disparagement. You have to be able to speak truthfully and fully if you are investigated. But you can't initiate things in many cases. But you can, you have to be able to respond. Likewise, other authorities.
So can I ask you a personal opinion?
Absolutely.
Do you think they should be opening up this confidential arrangements?
I think that one of the problems is that when you get into the public eye, you make yourself, someone who's under the spotlight, under the microscope. But I do think that you need to respect, the interests and the rights of the claimant, and it's not just up to the company, or in this case the company's founder and CEO, to disclose things just because he's in the public domain.
Plus, if the founder or an executive gives permission and the person says, okay, now I have permission, I can talk, even if what they say is not entirely true, as you say, it's going to affect not only obviously the person, but the company, and has such a domino effect,
Well, and
correct?
some people want to open it up because they want to be recognized, their moment in fame, and sensationalize things.
Right.
But you got to remember, at the moment of signing, these were two parties usually that have agreed that this is the way it has to be.
Well, there's also a new wave of litigation that's emerged in the last 10 years, which is a wave of defamation litigation that's predicated upon public statements about whether something happened or didn't. So you can actually have a situation where the agreement is breached, and that gives rise to one type of claim. But then there's public statements, for example, that this never occurred, this particular claimant is making up the story. Well, what's happening now, and this was made popular by guys like Michael Avenatti,
Right.
is take those victims and his clients and pursue the company, the harasser or the alleged harasser, and pursue them on a theory that they've been defamed. And so now we have, across the country, we have a new round of defamation litigation
Interesting.
that's emerging from these sometimes broken settlements and other times long ago incidents that may have never been settled.
So let's change channels back again a little bit, too.
Sure.
And thank you for those answers. Back to Michael Chinitz, the entrepreneur. What's next for the law firm? Now that you're into a new realm, and you must be getting a sense of where you want to go with this.
So I'm in about month 8, and I just hired my first full-time associate.
Congratulations, Mark.
No.
No, I'm just joking.
I could only be so lucky. I could only be so
thank
lucky
you.
to,
No,
to
he-
actually have Mark as a partner. But in any event, I hired my first full-time associate. Her name's Corey Muscatelli, and I have a full-time paralegal, and I'm looking to hire another admin person. And so the goal for me is to continue to provide very quality service primarily to executives and emerging companies across a broad spectrum. But looking forward, what I become really well known for in my present role is to advise executives through a lot of different problematic issues in their careers, including transitions that may not be smooth, and then also situations that come up where they need close mentorship and coaching. So it's not just legal advice.
The other thing, which is also very interesting, being on a legal show, are the top firms downtown, the large firms, are looking to you and recommending cases to you because obviously not only because of conflicts, but you have always enjoyed a reputation in this space.
Yeah, I do work with a lot of large firms in town. There are a number of matters for executives that they just won't touch because of either legal conflicts or business conflicts. They don't want to be in a position where they run into friction with their corporate clients, or they know that they need someone to work very cooperatively with them on, for example, the founding of a new company, the startup of a new company, where individuals need representation that are, instrumental to the start of the company. They need their own lawyers for a whole bunch of different reasons. One of the reasons that we talked about speaking about here is the whole issue of trade secret theft mitigation, trade secret liability mitigation, or risk mitigation, and that's something that I'm consulted on quite frequently, and that's coupled with non-compete.
It's getting bigger.
issues. It's getting bigger because of there's bills. Can't get into it in this time space, but there's both relatively new legislation at the federal level that's now really coming into vogue because the first cases filed under a federal statute, the Defend Trade Secret Act, that was passed in May of 2016 by the Obama administration. That's now coming into vogue because the cases are coming down, the verdicts are coming down, the judgments are coming down.
Interesting.
And then in Massachusetts, we had a new statute effective 2018 that's very similar to the federal statute in many ways. And so it's becoming a hot issue, and it's been a very hot issue in terms of damage to our economy.
We never worry about attorneys using up the full allotment of time on Radio Entrepreneurs. We've been speaking with Michael Chinitz, owner of Chinitz Law, LLC, with Mark Z from Mark Z Legal Staffing. Michael, if someone's looking for you and your firm, how would they find you?
Well, I try to have a broad presence, so www.chinitzlawllc.com. If you Google me, I have a strong Google presence. And I pride myself on getting back to people very, very quickly. And I have a good team to deal with issues when I'm tied up. They'll, handle them as well.
Mike, can we also have you come back to talk more about the trade secrets and what's going on with the statute and locally?
Absolutely. I'm happy to come back at any time. Just give me 24 to 48 hours notice.
Excellent.
We're going to take a break. Remind everybody we're at TBHR, Tarlow, Breed, Hart, and Rodgers. And this is For the Record, and we're talking to the top lawyers in the New England and Boston community with Mark Z from Mark Z Legal Staffing. We're going to take a break. We'll be right back.